Hello, everyone. Welcome to the first day of the University of Minnesota Law School Spring Alumni Week. My name is Jamie Snelson. I'm the co-chair of the Law School Board of Advisors Academic Engagement Committee. On behalf of the committee, I thank you all for joining us today for what I'm sure will be an engaging discussion of the regulation of social media. But first, a few housekeeping notes. This CLE is being recorded, and the link to the recording will be shared after the CLE. We'll try to leave some time for questions toward the end. Please type any questions you have in the chat, and we'll do our best to get to as many of those as we can. As you see, we have two members of our illustrious University of Minnesota Law School faculty on hand to explore some questions about how social media is regulated in general, and then more specifically, how that regulation might stifle speech, how it might protect minors, how it might impact workers' rights, how it might allocate risk among content creators and platform owners, and maybe some equally thorny issues as time allows. With that as a little teaser, let's meet our faculty experts. Alan Rosenstein is an associate professor at Minnesota Law, where he has taught since 2017. He's a senior editor and research director at Lawfare, a non-resident senior fellow at the Brookings Institution, and a term member of the Council on Foreign Relations. Before coming to the University of Minnesota, Professor Rosenstein served as an attorney advisor in the Office of Law and Policy in the National Security Division of the U.S. Department of Justice. He's authored a wide range of scholarship on constitutional issues and is a frequent commentator in the press. Professor Charlotte Garden is the Gray Plant Moody and Bennett Professor of Law at Minnesota Law. She joined the law school in the fall of 2022. She specializes in labor law, employment law, and constitutional law. Her interests include the intersection of workers' rights and the Constitution, how law supports or undermines worker voice and power. Prior to coming to the University of Minnesota, Professor Garden was a professor at Seattle University School of Law, and before that, she was a practicing lawyer in Washington, D.C. Also the author of impressive scholarship, much of it focused on employment and labor issues, including constitutional issues in the labor environment. So to our panelists, again, welcome. Thank you for sharing your time and insights today. Let's set the table with some basics. Alan, maybe you could describe for us the key aspects of federal and state regulatory frameworks that are currently shaping social media use and how those frameworks have evolved in the past few years.
Sure. So this is kind of an easy question to answer because there's not that much. Congress is not very good at regulating technology, or maybe it is very good at, depending on what you think, maybe it is good at regulating technology and that it does not regulate technology. But with respect to social media, there's not a ton. Now, there is some stuff about children, which I'll get to I can talk about in a minute. But on the broad question of social media, very little, actually. The main law is a law that actually further deregulates social media from what you might think of as the kind of common law baseline, and that is Section 230, which is this now infamous or famous or both statute that immunizes social media platforms from harms caused by content that is produced by their users. And that really has become the main piece of legislation that has sort of further empowered social media. When it comes to legislation that restricts or regulates social media, there's really basically nothing to speak of at the federal level with respect to adults. At the state level, things are somewhat different. There are some laws that purport to regulate social media. In particular, California has an important digital privacy legislation that limits to some extent what social media can do with user information. More notably, Texas and Florida both have enacted laws purporting to limit what social media companies can moderate. They call these sort of anti-censorship laws. Both of the laws are mired in litigation, in particular in the wake of the NetChoice decision from the Supreme Court from last year, again, which we can talk about. When it comes to children, there you do see some more regulation. At the federal level, the main piece of legislation is the Children's Online Privacy Protection Act, or COPPA. This is from 1998, so this is actually predates modern social media. But this basically limits what internet companies can do with respect to the collection of data on children 13 years and under. it's not a meaningless statute, but it's mostly a meaningless statute because it does not really require companies to do much to actually prevent children from under 13 from using their services. And there are plenty of children who, 12, 11, 10 years old who lie and, about how old they are and therefore get Instagram accounts and things of that nature. Um, at the state level, there are more muscular child protection laws that have been enacted, are in the pipeline in both blue and red states. But these are increasingly coming into their own legal difficulties. So Texas, for example, passed a law trying to put age verification on pornographic sites, making sure that people under the age of 18 did not access them. That law is actually pending before the Supreme Court right now. Oral arguments were held earlier this term. There are other examples of these kinds of legislation, whether they're child safety laws or whether they're child verification laws. But again, these are all kind of ensnared currently in a variety of First Amendment litigation. So to sort of give you an overall on your question, there's very little either at the federal or state level that is meaningfully regulating social media. And the one piece of legislation that is important, Section 230, is a highly deregulatory piece of legislation.
Got it. You alluded a little bit, I think, to other types of laws that are in some cases being challenged. Are those the ones that relate to content moderation and the like?
Well, so there are lots of things that are being challenged, right? So right now, the state content moderation laws, and again, these are laws meant to restrict content moderation, so prevent platforms from content moderating, or if you're a fan of the bill, censoring. It depends on sort of obviously which side you're on. Those are stuck in post NetChoice litigation. You have child protection laws, which are not about moderating content, but they're about restricting children from being able to go on these websites by requiring age verification, often in the form of the production of state ID. That's the Texas pornography law or anti-pornography law. Those are being challenged, again, not on the grounds that children have a right to use to access pornography, but on the grounds that adults do. And so a law that overly burdens a law that even if aimed at children, has the effect of overly burdening adult access can be unconstitutional. This was what the Supreme Court held in ACLU versus Reno. This is a landmark internet First Amendment case in the mid-1990s, which struck down what was then Congress's main attempt to regulate the internet, which is the Communications Decency Act. It struck down a provision that would criminalize giving children access to pornography, on the grounds that would have an excessively chilling effect on the ability of adults to access that kind of material. Then there are other laws that directly require, I think there's a law in California and a law in New York, though the law in New York might be pending. I don't know if it's been enacted yet, that would require social media platforms to modify their services to keep, in the best interests of children. Those laws are tied up in litigation on kind of void for vagueness, First Amendment grounds. So the First Amendment is a pretty big buzzsaw for this. I will say, though, we're still very, I think, early in what will be plausibly half a decade, if not longer, of litigation. And so we'll see what the First Amendment looks like at the end of this. But right now, the case law is pretty libertarian. It's pretty deregulatory. So I think lower courts are correctly viewing a lot of these laws with doctrinal skepticism, even though I think it's very much an open question how much the Supreme Court might ultimately, again, with respect to children, allow for more regulation. But again, that's going to take us 5, 6, 7 years to figure out.
Understood. Let's switch gears a little bit. We can come back to any of that as you each like. But Charlotte, maybe you could talk a little bit about how the evolution of social media platforms and their use by employees and employers has impacted traditional labor law concepts and practices too.
Yeah, sure. So one thing I will say is that that question has, there's more than a decade of the board dealing with the application of the National Labor Relations Act to social media. It comes, so there are some questions that are pretty well answered, such as like, can protected concerted activity take place online? Like resoundingly, yes. So, and there it's, not a question of it being really difficult to translate an in real life concept to the internet or to social media, right? It's just, to the extent workers can talk about their working conditions at work, they can also talk about them on social media. There were some like hiccups early on about like, if somebody likes a post, is that the same? Like, does that qualify as evidence towards the concertedness requirement being met? Yes, right, it turns out. But that kind of question has a really close parallel, the kind of question that can arise in real life. So, somebody tries to initiate protected concerted activity, it doesn't really work. Can that be covered by the National Labor Relations Act, right? Like, again, often yes. Likewise, employers making coercive threats about their employees, like that can happen, both in real life and online. And courts will treat the two circumstances, will treat the two contexts fairly similarly, or the board will and courts will affirm. There are a couple of recent high-profile cases involving employers' arguably coercive threats on social media, and their treatment by the NLRB. I'll maybe just mention them. They're both just kind of intrinsically interesting. They both involved tweets. One involved a tweet by Dave Portnoy, the Barstool Sports guy. He tweeted something like, the first of you, right, you being his employees, like the first of you to unionize gets sent back to the salt mines. The NLRB ended up saying that's a coercive threat. Third Circuit reversed, saying like that's a joke. So the question is really like, how do you deal with, or how do you figure out context online? Would an employee be coerced in their sort of ability to organize a union, or would they not? The other case involves Elon Musk. He tweeted ages ago that if his Tesla employees unionized, they, tweet was something like, why would you unionize when it's just going to mean that you lose your stock options? The NLRB again said that was a coercive threat. The Fifth Circuit recently heard that case, and they, in a what I would say is like a really strange opinion, said, we think that is fine, that it's fine that the board did that, but we also think the First Amendment prohibits the board from ordering that the tweet be taken down. So the Fifth Circuit's view is that somebody can post on social media a threat that violates labor law because it's coercive, but that the board is powerless to have it be removed. And so that is an interesting view of the scope of the First Amendment, I will say. Like, I tend to think that it's one way or the other, right? Either it's protected speech because it's not coercive, and that's also why it doesn't violate labor law, or the reverse, right? It's violates labor law because it's coercive and therefore can be ordered to be taken down. I find the idea that something can be both to be very unusual. Okay, there are some other sort of emerging issues related to, for example, employers' surveillance of social media activity, which I think we'll talk about a little bit later. But I think I've been talking for a while now, so let me hand it back to Jamie.
Yeah, well, you both telegraphed that emerging issues are being addressed and heard and hopefully decided by the courts. What's your prediction here as we sit in a dynamic point in 2025 about what's going to come up first and be decided, or where the issues or resolution of them will be advanced as we look forward here in 2025 and maybe into 2026 too? Open question to you both.
Yeah, I'm happy to start. I'm not sure. I mean, the Texas pornography child verification case is pending, but the procedural posture of that one is weird because the Fifth Circuit, as it has been doing lately, played very weirdly fast and loose with the controlling precedent. and read it in such a way as to apply, I think, no scrutiny at all, which is an interesting move. So I suspect what the court will do is we'll just remand to apply the correct standard, and then we'll just be back at the races of, intermediate or strict scrutiny or intermediate plus or strict minus, and the sort of kind of scholastic head on a pin nature of a lot of this kind of First Amendment doctrinal analysis. Again, the same thing with NetChoice. We're stuck in this lower court endless litigation over facial versus as applied challenges, and how do you do the as applied challenge? So that'll take a long time to get back. I think what's fun about this area of law, and I'm very curious, Charlotte, if you agree with me on this, is that there, and maybe the labor side of this is somewhat different, but at least for the pure social media cases, there's not an obvious political valence to a lot of this. This isn't like abortion or gun rights or affirmative action where you really know what every single justice is going to say, and the oral argument kind of has this kabuki theater like nature to it. Again, not because anyone's acting dishonestly, but like it's really baked in. Here you have these really interesting, cross coalitions that just don't seem that related to the underlying policy or political preferences of the justices. And you really saw that with NetChoice, where you had, Kagan writing an opinion for her and Sotomayor and the chief and Kavanaugh and Barrett and Jackson, but Jackson only signed on to some of that opinion, and Barrett wrote a kind of concurrence that undermined a lot of the opinion. And then you had Alito and Thomas and Gorsuch on the other side. I think you could see something very similar with the Texas case. You saw something issue I haven't talked about, but maybe worth talking about a little bit. We saw that a little bit with the TikTok opinion, which was a 9-0 opinion upholding the TikTok ban. But the two justices who clearly were least happy about it were Sotomayor and Gorsuch. And so one of the things that makes this really fun as a scholar is the unpredictable nature of it, and the sense that the justices they're really thinking from first principles rather than, well, I thought X on this for the last 20 years, so that's what I'm going to write in this opinion.
Yeah, I really agree with that. I mean, I think one of the really interesting things about the NetChoice decision was the way some justices, both Justice Moore on the left and Justice Moore on the right, kind of flipped their usual position on the extent to which the government can try to create a more fair kind of marketplace for speech. So,
and Jamie, let us know if you want us to I don't know, I don't want to steal your moderator thunder, but if you want us to if you want to get into NetChoice, we can give a 30-second on what it is we're talking about.
Yeah, right. These are content moderation cases, right? But if you could give us the quick sip, that'd be great.
Why don't I give the 30-second and then go back to you, Charlotte, on sort of what the opinions are. Yeah. So the NetChoice cases arose from two state laws, one out of Florida, one out of Texas, that each tried to limit what social media companies could moderate. And the background to this is that obviously platforms moderate. Moderation is in some sense the product, actually. It's very core. And there has been for a long time a concern among conservatives that social media companies are biased against them. The reality is quite complicated. It's not clear that they're biased against them. They might be biased against them. Certainly the people at the platforms code left, though maybe that's changed in the last 6 months. The reality is very complicated, but there's certainly been a perception that this is the case. And so the Texas and Florida laws were actually very self-consciously written, kind of push back against this perceived liberal bias. The problem for the laws is, or the problem and the opportunity for the laws actually, is that there's a very, very complicated doctrine going all the way back to the even before, but the kind of 60s and 1970s, about when the government can require individuals and platforms and companies to host other people's speech. And so there's this one set of cases going all the way back to this famous case called Miami Herald versus Tornillo, in which the court says, look, companies have First Amendment rights, editorial rights as to what they themselves carry. Then there's a different set of cases like Pruneyard, cases like now I'm embarrassed to say I forget the name of the case, but involving actually law schools and their, whether they can be forced to host military recruiters, where in other circumstances, the court says, look, there are certain circumstances where hosting someone else's speech is not an expressive activity, so the First Amendment doesn't really apply. And so the question for this case was, what are social media companies like? Are they more like newspapers and which have expressive editorial interests, or they're more like shopping malls and law schools that don't have expressive interests? Simultaneously, the other wrinkle for all of this was that when NetChoice, which is the industry organization that brought these cases, they brought them as facial challenges. So they said, look, these laws are always and forever unconstitutional. And the courts, the 11th Circuit, which struck down the law, and the 5th Circuit, which upheld the law, treated the litigation as facial. And the problem is it got up to the Supreme Court, and very quickly it became clear that these were not good facial lawsuits, because actually the breadth of these laws was quite stark, and they applied not just to sort of the paradigmatic example, which is, let's say, the public Facebook newsfeed, but to a WhatsApp private message, or to Uber Eats, or to like a million other examples. And they might also apply to AI algorithmic moderation, and that might be its own thing. So basically, what the opinion in NetChoice did was, maybe punted is unfair because this really was a problem. It said, look, these are not good facial challenges, right? Everyone needs to start over from the beginning and do them as applied, zeroing in on exactly what the specific litigant is complaining about with the law with respect to them, and then we will try this again. But in addition to doing that, the various coalitions on the court also wrote a bunch of dicta saying, and when you do that, keep these things in mind. So the Kagan majority wrote some dicta that was very strong on the First Amendment rights of the platforms. Justice Barrett kind of split the baby a little bit, saying, yeah, but generally yes, but AI algorithms might be different. The Alito opinion basically said, this isn't speech, this is censorship. The Jackson opinion, I think very much to her credit, said, why are we doing all this dicta? Dicta is bad. I don't want to do this until I have to in 5 years. And so that's where that's why we're back in the situation. So sorry for that mini lecture, but Charlotte, back to you.
Yeah, so one thing I will say is that since the NetChoice decision, the case has been remanded to the 5th Circuit, and then from there remanded to the district courts. The 5th Circuit said there has to be just so much discovery, right? So, Alan, I think you said there could be litigation over these issues for half a decade. I think there could be discovery in this case for half a decade, right? Because the NetChoice plaintiffs tried to sort of say, well, on remand, we should be allowed to sort of develop these factual issues to kind of a limited degree. The court was like, oh no, you have to go back and figure out how every platform to which this law might apply engages in content moderation, and the extent to which that content moderation qualifies as expressive and is therefore covered by the First Amendment, because what we have to do is ultimately be able to say, here's the scope of situations to which this law applies that raise a First Amendment problem, and here's the scope of situations to which this law applies that does not raise a First Amendment problem. We have to be able to compare them, and that means we have to sort of know the precise weight of both, sort of sides of the scale, if you like. So that's so I'm sure NetChoice was deeply unthrilled to get that order, right, and get sent back for extremely extensive discovery. So in the Kagan opinion, right, in this dicta, there is some discussion of whether and when the state's interests in regulating content moderation might satisfy heightened scrutiny that applies. And the Kagan majority says the government can't just assert an interest in improving or balancing the marketplace of ideas. So that is interesting, right? The Kagan majority says this is related to the suppression of free ideas. It just cannot be a qualifying state interest at all. So that is consistent with consistent with various important First Amendment cases, including Citizens United, right? In Citizens United, the court says that in the election context is called the anti-distortion rationale doesn't qualify as a can't qualify as a government interest because it sort of inherently violates the First Amendment. So when in previous cases, the court had said government can regulate corporate election spending in order to achieve a fairer marketplace of ideas, right? The court says that's trying to affect the composition of people's expression in order to, or of the total marketplace of expression in order to sort of change its composition. That's inherently a First Amendment problem. And so in the election context, it's been the more liberal justices that say government ought to be able to regulate in a way that is aimed at avoiding kind of market distortion by just people with more money. And the more conservative justices saying like, no, that is inherently a First Amendment problem. In this case, you see that reverse and sort of do a sort of nearly perfect 180 with the more liberal justices saying like, no, that's categorically not permissible. And I don't read it in a way, I don't read it as we've said that this is, we've said this is impermissible. I didn't agree with it there, but it's the rule. Like I read it as like a more full-throated endorsement of the idea that the anti-distortion principle is just unacceptable in this context. So I think that's interesting. Like I think it reflects a real kind of shakeup. I mean, both of the laws here are very much kind of conservative coded. But as Alan pointed out, there are other, sort of California, New York, right, other states passing other kinds of content moderation laws that, would code kind of the other way.
And can I just say something really just to jump on something Charlotte said? One thing that I on this anti-distortion rationale, one thing that I was kind of surprised about and thought was somewhat short-sighted is there were a lot of kind of progressive legal types who very much disliked the Texas and Florida laws, and I understand why they did. They weren't great laws. But I don't think they appreciated that this is an opportunity for the court to cut back on this resistance to anti-distortion arguments. And it is exactly this resistance to anti-distortion arguments that has led to a regime of this very kind of Lochnerized First Amendment, as the academics say, that progressives, I think with some justification, really dislike.
So for folks following along, that's the two NetChoice cases that Charlotte and Alan have been talking about. Moody versus NetChoice and NetChoice versus Paxton are the two cases, and both remanded, correct?
Yes.
Moving along a little bit, Alan, I think you mentioned TikTok, and I want to come back to that. But before that, let's talk a little bit about AI, which I think you brought into the discussion, Charlotte. Seems like generative AI in particular might be a transformative force on social media, heightening risks like misinformation and manipulation, maybe many others. Is that true? And if so, does that underscore the urgency for regulation or just make meaningful regulation harder? Any thoughts?
Let's see. I think this question is queued up to let me talk about my imminently forthcoming edited volume. So see, I don't know if that's what Jamie meant, but that's what I'm going to do. I am a co-editor of a forthcoming volume, should be hitting shelves any day now, on misinformation, disinformation, democracy, where we have a number of contributors from sort of various, from a range of countries, or talking about a range of countries and regions, and their various approaches to regulating mis and disinformation on social media. And, when we started this project, I would say that in particular, one of my co-editors thought like, oh, maybe we're going to find the country that has figured this out, and has figured out how to meaningfully deal with the problem of online mis and disinformation, while preserving, the robust free speech rights that, ought to be part of a liberal democracy. And as it turns out, that is not what happened, right? The contributors to our book explain a kind of range of balances that the countries or regions they write about have struck, balancing on one hand, right, free speech against on the other, the harms, including sort of electoral or political harms that come with mis and disinformation. I think like the phrase "the devil is in the details" is it may appear in like every chapter. And the upshot is that countries have mainly, to the extent countries are really trying to deal with this, is often through a kind of like self-regulatory mechanism, like putting pressure on platforms to do more and report what they're doing and sort of report how effective it is to respond to mis and disinformation. So like the EU approach, right, kind of really tries to encourage platforms to do things like demonetize disinformation distributors. As far as I can tell, the subsequent research mostly suggested it hasn't particularly been effective. Yeah, I would say that this is a problem that we have not solved. It is perhaps unsolvable.
If I may just hop on that for a second, you know, generative AI, and maybe I'm biased because this is essentially all I study now, is such a tectonic technology, right? I mean, it is, at least I think that it is such a huge deal that it's never straightforwardly good or bad for anything, right? And I think it could be a disaster for mis and disinformation. It could be really good as well, because frankly, ChatGPT is a lot more rational and reality-based than most people, right? Myself included a lot of the time. And so, you know, one can imagine a world in which people actually get a lot better information and a lot more calm and rational information by talking to these chatbots in some way. And also one can imagine a tuned version of this. You know, some bad actor takes an open source model and tunes it to be as inflammatory and as, you know, disinformatory as possible, and then uses video and image generators to create an army of bots and utterly destroys the internet. Or one can imagine both of those things happening at the same time. There's this great phrase, I think it's the devil's in the details, that I'm going to, I think applies here as well.
Understood. Well, I mentioned it a minute ago, so I'll go back to it at least for a moment. When we first scheduled this session, we all thought that there would be big TikTok news to share, and there really isn't. But curious to get your thoughts on where that's likely to go in this period where we're still kind of waiting what's going to happen to TikTok in the United States.
So for my sins, I have somehow become TikTok guy, because I've been following this obsessively for the last year. And I have to say, it's become a real farce, because you have a situation in which you have a law that is extremely unambiguous. It was upheld by 9 justices and 3 lower court judges. I mean, so we got, you know, 12-0. And the Trump administration, and I should say that I put some blame on congressional Democrats and also the Biden administration for also going soft and wobbly on this. But in particular, the Trump administration, which last time I checked has a duty to take care that the laws be faithfully executed, is just not enforcing the law and is inventing totally made up extensions based on nothing, like truly nothing. And is, you know, convincing the companies that do business with TikTok, Oracle and Google and Apple, to go along with this, despite the fact that the law's penalties for doing business with TikTok are actually quite high. And so, especially if you're Oracle and you're providing literal service to TikTok and hosting for TikTok, you have probably at this point accrued at least $500 billion with a T, $500 billion of liability that you cannot be sure will not come due either by Trump or a future president. And I will say, there's a company called Akamai, which is one of these internet infrastructure companies that also does business with TikTok. And they filed in their 10K quarterly, you know, shareholder report a really remarkable statement. They said that they have accrued substantial legal liability for doing business with TikTok, and that they cannot be assured that the Trump administration or a future administration will not impose that liability on them. So you have a situation in which TikTok is in this kind of Schrodinger's neither dead nor alive situation. There's zero, it's totally unclear what's going to happen, because this is now wrapped up in a massive trade war with China. And of course, the Chinese government is not going to give its permission for ByteDance to fully divest of TikTok, while Trump is imposing infinity +1 tariffs, or, you know, whatever it is as of this morning. And a bunch of giant American companies have voluntarily exposed themselves to potentially ruinous, I mean, company ruinous liability, and are now subject to profound blackmail, for lack of a better term, by this administration, that has, as with many other areas, totally basically has decided that it gets to choose which laws to enforce. And what's amazing is that this has totally overshadowed the incredibly big First Amendment stakes of the actual, like no one is actually talking about anymore. The fact that the Supreme Court issued an extremely important, I mean, truly, for the casebooks, opinion on the First Amendment speech as it applies to foreign platforms. No one's talking about that because it's been totally overshadowed by this rule of law story that's now happening. Sorry, I have many feelings about TikTok that I'm clearly working out in real time. My apologies to the audience for this impromptu therapy session for me.
Thanks for sharing. Fascinating.
Yeah,
Sure.
I mean, I'm definitely not the go-to expert on the TikTok ban, but yeah, I really I agree that the TikTok ban is a source of political leverage. It's an extremely important story here, really troubling. Also, realizing I realize I have to slightly correct something I said earlier. I attributed the back to the salt mines tweet to Dave Portnoy. It was not him. He was the subject of a different NLRB enforcement action arising out of a tweet. It was actually Ben Dominic who gave the salt mines tweet. So I don't want to wrongly attribute the potentially labor law infringing tweets to the wrong Twitter account here.
First Amendment lawyers are particularly sensitive to accurate statements about public figures.
Well, since we talked a little bit about international environment with TikTok, maybe now would be a good time to talk a little bit about the fact that US-based social media platforms operate in a global environment where regulations from key markets like the EU and UK impact operational practices and data handling and content policies and safety features in those geographies. Are international social media regulations inevitably impacting US-based practices too? Any thoughts or comments on that?
I think there is a lot of sort of talk about the GDPR, and I certainly click I agree more often when I'm visiting a website.
That's exactly what I was going to say. There's a lot more clicking.
Yeah. It's hard to say more, for me to say that there's more effects than that. I mean, look, I think I think there's a lot of potential for more conflict between the US and the EU about social media platform regulation. Certainly there's been some sort of some signals about that. The EU adopts a more regulatory approach, especially with some categories of harmful speech, right? Such as some categories of hate speech. I think it's likely that there will be some kind of US government sort of saber rattling about that. But yeah, I'm not sure I've got a prediction about how that plays out.
Yeah, I mean, one thing I will say is that there's definitely, I think, room for social media companies and American tech companies to push back. I mean, this is not a social media example exactly, but I think it is somewhat related. OpenAI, for example, delayed many of its offerings by weeks, if not months, in various EU countries because they said, look, we have this really cool voice assistant, but we can't deploy that in the EU because of all sorts of regulations. And what they were not willing to do was to cripple their U.S. services just to maintain parity with Europe. So I think there's this constant push and pull between the Europeans, who, the charitable reading is care about the data protection or data privacy or whatever of their citizenry and are not going to compromise on that. The less charitable reading is can't produce their own tech sector, so they've decided to just regulate other people's tech sectors. There's elements of both of that are probably true. There's this constant push and pull between, how much of this are the U.S. tech companies going to swallow, and how much of this are going to say, no, we're just not going to do business in Europe on this particular feature, and call the Europeans bluff because, if a U.S. company turns off its services in Europe, sure, it's going to harm the U.S. company, but there are going to be a lot of angry Europeans calling their I'm not exactly sure how it works. They're a member of the European Parliament or whatever the case is. So there's chicken being played on both sides here, I think.
Yeah, obviously the balance between regulation and stifling innovation, which is the tension that I think we all feel. I was just traveling abroad, and Charlotte, to your point, found myself clicking "I agree" thousands of times just to get the most basic interaction with technology there. So that's something that I hope is not coming to a theater near us here in the United States, but we'll see, I suppose. Um, Talked a little bit about challenges and different regulatory approaches. Um, Maybe we could talk a little bit more about the inherent challenges in regulating a medium as dynamic as social media. I think many of us think of it as a decentralized, but is it, or is it really quite centralized, and is that part of the conversation or the problem?
Yeah, I don't think it's particularly decentralized. I mean, there are certainly decentralized alternatives. I got very excited and wrote a paper about Mastodon when that was coming out, and because I thought that it was and it's very interesting. And certainly, I think decentralization is growing a little bit. But at the end of the day, there are only like 4 or 5 companies, and the reason is that social media um, uh, naturally consolidates. Some of this is because of monopolistic practices, but mostly it's actually because of the dynamics of how social media works, which is that social media platforms have what are called network effects, where the value of the platform is not just about its features or its content moderation, but it's also about other people on the platform. And so what that naturally leads to is kind of winner take all effects, where naturally, once a platform is slightly better than its competitors, it naturally rises to the top, and so you have kind of like a power law distribution, where you have this very small number of giant platforms clustered at the top, and you have a very long tail of cool niche platforms that don't really matter that much at the end of the day. So um, centralization makes it both easier and harder to regulate. So it makes it easier to regulate in that you're only regulating a few targets, right? If we were to fund this adequately, everyone constantly complains that the government's too slow, and most of the government's too slow because we just don't fund it sufficiently, or the government's slow because we've decided to make the government too slow. And the antics of the last couple of months are not helping with that. So yes, right now the government can't regulate anything at the moment, but that's very much a choice that we have made, and maybe we will unmake it in 2 or 4 years' time. So on the one hand, the centralized nature of social media makes it easier to regulate. On the other hand, it also means that you have a small group of players who are very well resourced. I mean, these are literally the biggest companies in the world. They're very incentivized to collaborate to push back against regulation, right? Because you have a classic situation where the benefits of regulation are diffuse, right? They, to the extent you think that they're good, they come to all of us, right, as individuals, and so none of us individually has much of an incentive to really lobby Congress. But the cost of that regulation fall on a very small number of regulated parties, and so they have the incentive and the coordination ability to push back. Now, if I were a regulator, I would still much rather have a smaller field, and by smaller I mean a field with fewer participants to get my arms around. But it does pose challenges because you're some mid-level civil servant in the Federal Trade Commission, and your counterparty is Meta, which has infinite, last time I checked, I think literally infinite dollars at its disposal. And then all of this is to say, and this is all with the First Amendment hanging over, right? So again, I cannot emphasize enough how uncertain, forget the regulatory landscape is, just the basic constitutional landscape is, right? I mean, I think if you're a regulator right now, you're in the same level of constitutional uncertainty as if you're like FDR in 1938 with respect to the Commerce Clause, right? I mean, it is that level of I have no idea what I am and am not allowed to do. And the only way I can figure it out is just by regulating and then litigating for 5 years, which is, the way it's supposed to work, but makes it very difficult. It's great for people like Charlotte and me, right, who make our lives writing law review articles about this. It's not so great if you're like an FTC bureaucrat.
Is it different if you're a state level regulator? You mentioned the content moderation laws. Is that likely to be an area of more activity?
I mean, yes, and like especially similar to what Ellen was saying before, like especially with respect to children, right? Like a bunch of states have recent statutes that affect how children use social media. So things like, if a minor is using social media, the platform has to limit how they communicate with other people, especially other people who they aren't sort of like directly friends with, or aren't directly connected to. And there's a lot of kind of in litigation at the kind of preliminary injunction stage there. But I think the kind of proliferation of those statutes, and I agree their future is uncertain, is a signal that when states feel really motivated to do something about something they like perceive as a social media related problem, they can move reasonably quickly. Whether they move carefully enough, right, or whether the things they're doing are a good idea, is another question. But they can definitely like move things out of their legislatures and into the courts.
Right, likely leading to challenges in state courts that ultimately might rise to the federal court as well. Is that where you see a lot more activity, similar to the NetChoice cases, that process?
Yeah, I mean, I think getting ready for this, I think I've realized that you can find all these cases by going into Westlaw and searching by party name for NetChoice. That quickly brings up this long list of mostly preliminary injunction cases, a lot of them in federal court, raising First Amendment questions about these attempts to regulate either content moderation in general or specifically with respect to children.
So I don't think we have any questions in the chat. What?
So we have one in the Q&A.
Okay. I am not seeing that. So if you could go ahead. Okay, here we go. Okay, so the question in the Q&A, can we talk about government entities that are on social media and what the law says about content moderation on their social media pages and posts? Can a state, federal, or local government entity choose to allow comments on some but not all of its posts? Are there any restrictions on a government entity choosing to cut off comments on their social media pages and posts altogether if the comments are too many or becoming toxic?
Yeah, so in
Want to
those,
jump on this one, Charlotte?
yeah, in those cases, the question is often whether the government has created a forum. So, you sort of remember forum analysis from kind of general First Amendment law. You can apply that kind of question here. So when government creates a forum, when government creates a limited forum, its restrictions have to be reasonable and viewpoint neutral. But when government creates a forum, it can also cut off the forum. So if government wants to use social media as a one-way vector for information to go out, but doesn't want to receive commentary back, that's, I think, generally fine. Where government entities and where individual office holders run into trouble is when they either selectively delete comments or selectively delete or selectively accept comments based on viewpoint or in an unreasonable way, or sort of say like this individual constituent like is blocked and therefore they can't access this source of government information. There can be a preliminary question in those cases about whether the account like is really a governmental account or not, but if it is, then then I would say generally the government's approach to handling that account has to be viewpoint neutral and has to be reasonable.
Yeah, and I would just add, I mean, there was a case about that preliminary question last year, in case called Lintke versus Freed, and this was asking the question of when is government officials' use of social media state action, such that you even ask all the questions Charlotte just raised about limited public forum and viewpoint neutrality and stuff like that. So this comes up because often. And you're seeing this, now at the highest levels, with Donald Trump on Truth Social and JD Vance, who posts a lot. A lot of government officials are using social media, and sometimes it's not clear whether they're using it as government officials, whether they have the authority to do so. I mean, obviously with Trump and Vance, it's kind of obvious that they have the authority to do so, but alternatively, whether they're using it just in their personal capacities and whether it's blended. And so what the court says, you have to look on a sort of per host basis about what specifically was the government official speaking as a government official or as an individual. And if they're speaking as a government official, then yes, the reply thread, under that post is potentially a limited public forum, and then you do all this stuff Charlotte was talking about. But if it was just, hey, I had tacos for breakfast, and the response is, you stink, right? Then there's an argument that no, it was just speaking in their personal capacity. I think what's tricky is that both it's very fact specific, and also Lindke versus Freed, the Supreme Court case was about I looked this up just now. It was about the city manager of Port Huron, Michigan, which is to say not a high level government official. And so there I think it's more reasonable to say, look, he's a government official, but he's also just some dude, and so he is allowed to also have a personal life. I'm not sure the president of the United States is allowed to have a personal life, like separate from being president of the United States. That's kind of the whole point, right? So the rules for when something becomes government speech and state action might be different depending on sort of how high up the food chain of government officialdom you're looking at.
Another question that I'll tee up for you both that came up in the Q&A. Are there any First Amendment implications attached to how states and federal government regulate data that social media companies collect from users, like the California Consumer Privacy Act? Any First Amendment implications attached to requiring companies to delete data when a consumer requests it?
Yeah, so I think there's a simple answer, which is yes, there are First Amendment implications to this. What the First Amendment implications are, that's the hard question. So we obviously have a ton of privacy statutes generally in the United States, both in the federal and the state level. And those generally have not been thought necessarily even to implicate the First Amendment, let alone violate it. So like everyone's heard of HIPAA. No one thinks that HIPAA is a First Amendment issue. It is what it is. You can argue pro con, but no one's like, but it's a First Amendment problem that the government restricts the transmission of health information. Or, Charlotte and I work at a university, so, we're limited very much of what we can say about our students under, I think, FERPA, one of these, student data privacy statutes. And then in the 2000s or 2010s, I forget when, the court kind of threw a bomb into all of this with this opinion called Sorrell. And that was about the restriction on the sale of prescriber healthcare prescription prescriber data. And depending on how broadly or narrowly you read that opinion, either the data privacy regime that has existed is largely unchanged, does not really implicate First Amendment, or every single data privacy regime is now squarely a First Amendment question because it's about data, and data is speech, and now you're off to the races. So my unfortunate cop-out answer is yes, but stay tuned. This is like one of the very long list of digital First Amendment questions that the courts will have to address in the next decade or so. I'm curious, Charlotte, if you agree with how I sort of framed that.
I do, yeah. I mean, in the First Circuit, the case that eventually became Sorrell had the court went the other way, right? And one thing the court said in that case is like a regulation on the sale of data is the same as a regulation on the sale of beef jerky. And I have to say, I kind of like the beef jerky analysis. Like, I think I'm like alone in the legal academy and thinking that would be a reasonable way to think about this case. But the Supreme Court said, no, the sale of data is speech. This incidentally is one of the opinions where you start to get the more liberal justices in dissent saying our deregulatory approach to the First Amendment is really leading in bad directions. But nonetheless, right, the Sorrell Court opinion by Justice Kennedy, characteristically hard to pin down opinion, I would say, suggests that there is some relatively broad protection for under the First Amendment for the sale of data. And to the extent people have questions about what does this mean for example, net neutrality, that's an excellent question.
I think that's all the questions that we have in the chat and the Q&A. Any final comments or thoughts, Alan and Charlotte?
Yeah, I will just sort of say kind of what I came back to, which is, I as frustrating as I find this area of law, because so much is uncertain and unclear, and so much of the stuff that like I want to do in AI regulation, there's this giant, but the First Amendment may be cloud hanging over all of that. I actually find it also much among the more intellectually exciting parts of the law. Again, not just because so much of it is a greenfield, but because it does not match neatly to political or partisan preferences. That like there's real thinking, real first principles thinking happening, and that's always sort of fun to see. And it just gives me kind of like, as an American, it gives me a very warm, fuzzy feeling when like Kagan and Kavanaugh are yelling at Alito and Sotomayor, right? Like that's the kind of intra-court fighting that I want to see. That makes me feel like our institutions are doing okay. And because there's so much other bad news about our institutions, seeing that those kinds of fights rather than, oh, you got the liberals and the conservatives, that makes me feel good. So despite my frustration, I actually quite enjoy playing in this space and thinking about all these legal questions.
I guess I'll say I agree with Alan's premises. I read them slightly differently. I guess I think the partisan implications in this area are sorting themselves out. And I tend to think that there is still like a way that partisanship is very important in kind of driving these cases. So I think I tend to see more partisanship, for example, in the various NetChoice opinions than maybe Alan does. But who knows?
Well, thank you both for your insights. Thanks everyone for attending, and I hope everyone enjoys the rest of Spring Alumni Week. Have a great week, everybody.